This addendum is actually for lessor and lessee. So it is universal. You can use it for any of the standard leases that we described. Why do you need to use addendum? You use addendum because there may be special conditions or provisions that you don't, that the standard leases don't provide. So you just have to kind of add it in here. Now, these standard provisions could be many different things, and some of which you don't really know how to draft because you're not a lawyer, right? So you really would require some expertise from our legal department. And our legal department is currently handled by Tiffany Garrett. She's one of the attorneys that I hired in my firm. And she's available to provide attorney services. If you ever have a special provision or special condition that you want to include or add to the standard lease, Tiffany is really the person you should talk to, okay? And if you want Tiffany's email address, her email address is tiffany@kennytanlaw.com. kennytanlaw.com is just my law office website. And Tiffany is just Tiffany. Her last name is Garrick, Garrick. Now, some of you have dealt with Tiffany before. She's an excellent attorney. She writes very, very well. So whatever your unique situation it might be, Tiffany is usually able to draft it properly for you. Some of these are so difficult to draft, you wouldn't be able to do it yourself, okay? So if you ever have any special provision, you will just go ahead and do an addendum for it, okay? It's right here. All right. Okay. Other addendum that we use in conjunction with leases would include an arbitration agreement, for example. This arbitration agreement, you open it up, it's called a standard lease addendum. In all of the 6 kinds of standard leases that we prepare, the parties have the option to go for arbitration in the event of a dispute. You know, do you want to go to court or do you prefer arbitration? If you don't know what an arbitration is, it is kind of like a trial, but it's not happening in the courthouse. It usually happens in the office of the arbitrator. And the arbitrator is acting like a judge. So whatever decision that the arbitrator gives you, that's the decision for the case, for the dispute. Arbitration is cheaper and is less time consuming, therefore is always preferred than to go to trial in the courthouse. So if your client wants to prefers arbitration, this is the form you're going to use. So you just go ahead and fill out the information here, okay? All right. So remember this one. Of course, if your client does not prefer to arbitrate, then you do not use the arbitration agreement addendum. Okay. There's a couple of other ones that I want to go over with you. Now, some of these forms, you might be thinking to yourself, Kenny, why do I need to learn this? Well, you need to learn this if you want to do commercial transactions. Well, what if you say, Kenny, I'll never do commercial transactions. I'm a residential agent. Never say never. All I can say is never say never. Because sometimes you may have a client that say, hey, I wanted to rent a place for hair salon. And you tell, I can't help you because I'm a residential agent. That's just too bad. Because you have the resources, you have the ability to actually do the transaction, and you tell the person, hey, I'm a residential person, I can't help you. Okay. You can do any real estate transaction with your license, whether it's commercial or residential. It doesn't matter. Okay? You can do many things with your license, to be honest with you. Okay? So never say never is what I'm saying. So, and it's frustrating. Sometimes you get a huge deal presented in front of you, and of course at that time you can always refer it to one of our commercial agents and get a referral fee. You can do that. Okay? But if you don't want it to be just a referral, you want it to be able to do a transaction, these are the forms you have to learn how to use. You're not going to remember everything that I'm telling you today. However, this is a recorded instructional video. What that means is you can always refer back to the video and watch it again. If you ever want to prepare certain things that require addendum, today's instruction, today's training is all about addendum. Okay, all the leases have been covered in previous videos, right? So yeah, just bear with me. Plus, by listening in and watching this, it also helps you in understanding some of the commercial practices. Okay. Here's another one. This is another addendum that you will need. It's called the guarantee of lease. They don't call it an addendum. They call it a guarantee. But it acts as an addendum because when you prepare a lease, one of the things that you want to consider is that do you require a person to guarantee the lease? For example, if you're a landlord signing a lease with a tenant, and the tenant is a corporation, you want a person, a natural person, to guarantee the lease. Most of the time, you will want a guarantee if you represent the landlord. So this is the standard form for guarantee. So you know, at least know which form to use. I really will not go into the language for the form because mainly it's just the legal stuff. Just understand that if you need a guarantee for a lease, this is a form that you will use. Okay? All right. Of course, once you sign an agreement, it's binding on you. All right? Now, what other addendum do you need to have? Let's see. Option. Any kind of options is an addendum. If you have like, you know what an option is? Say for example, you are in the business, you are a tenant, you want to rent out a space for your business, but you don't know how long you're going to be here. You don't know how successful your business is going to be. So are you going to sign 20 years? Or would you rather sign a 5-year lease with 3 5-year options, for example? If you sign a 5-year lease with 3 5-year options, you are only committing to 5 years. So if your company goes bankrupt, they can only go after you for the 5 years and not the option years. But if you move into this place and then your business started to do well, you wanted to secure this space, and the options allows you to secure the space. That's what we call option. It means that you don't have to use it, but if you want to use it, it is available for you to use. That's what we call option. Okay? An option is basically an offer that is held open. So basically, I have an option for to extend the lease for 5 more years. I can choose to exercise it or not exercise it. Okay, so some.
So it's the advantage only to the leaser. Leaser cannot lease to someone else if they pay prior amount after 5 years.
That's right. So if you represent the landlord, but then that's one way to attract the tenants, though, because you know, maybe not many tenants want to commit themselves to a very long lease. Okay. You know, option you can have option to extend. For example, this one is an option to extend. Okay, look at the option to extend. And again, it is a standard lease addendum. So if you want to negotiate, if you are representing the tenants, you want to negotiate to have the ability to extend the lease without the commitment, you need an option to extend. And the way to do it is to use this particular form. It is called the option to extend. I'm sure you know how to fill this out. The date, and then the lessor's name. Lessor means landlord. And then the lessee's name. Lessee means tenant. Address of the premises. Now, paragraph number. Let me talk to you a little bit about paragraph number. You do not reuse paragraph numbers. Once a paragraph number has been used in the standard lease, if you want to add new paragraph, you always start with the next paragraph number that follows the last paragraph number on the lease. If the last paragraph number on the lease is number 39, and this is the next paragraph, you put 40 here, okay? Because you do not repeat paragraph numbers, right? Okay. And then it says here, options to extend, lessor hereby grants to lessee the option to extend the term of this lease for, now this one you can say, now this is in terms of months though, right? So, but it could be years though. So you can say, let's say for example, the option to extend this lease for 60 additional months, commencing when the prior term expires. Maybe it has, right, I'm sorry, it's not 60, but let's say it says 2 additional 60 months period. If it's 2 additional 60 months period, it means that you have 2 5-year options on it. If you have 2 additional 60-month period, it means you have 2 5-year options. Correct? Yeah. So let's say the original lease is a 5-year lease, and I put in here 2 additional 60-month period. I am signing a lease with a 5-year term with 2 5-year options, right? Okay. And then it says here, in order to exercise an option to extend, lessor must give written notice of such election to lessee must give written notice of such election to lessor, and the lessor must receive the same at least. Okay, this one talks about how much notice you have to give your landlord if you want to exercise the option. Now, let's say if I put at least, let's say 90 days, okay? Oh, it's expressed in terms of months, or expressed in terms of months. At least 3 months, but not less than 6 months, let's say. All that means is I have to watch out for the deadlines to exercise the option. If I miss the deadline, I lose the option. Let's say, for example, I put at least 3 months, but not more than 6 months. Let's say the lease expires on December 31st. All right. By what day? What is the last day I can exercise the option?
September 31st. Or
October 1st. Actually, you know what? To be safe, I'll use September 30th, right? I'd rather safe than sorry then, right? because the last day is actually 90 days, right? Before December, I mean, it's actually 90 days before December 31st, okay? Then, and then the earliest I can do it is June 30th, right? June 30th is the earliest day I can tell the landlord I want to exercise the options. But September 30th is the last day. If I miss the deadline, what happens to my lease? It ends if I miss the deadline. No second chance, unless the landlord wants to give you a second chance. You know how many times I've gotten calls from tenants that say, we didn't know. It's not that you didn't know, you didn't pay attention. That's what happened, right? You knew because you signed the lease. You just did not pay attention, okay? It's important you pay attention to this.
So you have to do 3 months before?
That's right. The deadline is 3 months before it expires.
Yeah.
Commercial is very different.
So that means the last day is September
30th.
30th? Oh, that's,
So you got to remember. And then it tells you, you exercise it. Can you do it orally? No. What does it say here? It says written notice, right? Yeah, it says here written notice. Can you call out the landlord, say, hey, I'm extending it? And the landlord doesn't say anything. Now, what if you call up the landlord, I'm extending it, and he say it's okay? Then it's binding on him or no? Well, actually, it could be binding, provided you can prove it. In court, he's going to say, I never said it. What if you say, I never said it? Then what do? You're stuck with that, right? You have no way of proving that he said it, though, right? So don't you want to do a written notice rather than an oral notice, right? You know, I have a tenant, sometimes they miss the deadline, right? They say, oh, I orally told him. He said it's okay. Well, how are you going to prove that? You can't prove that, can you? That's right. You can't prove it.
So even you write to the
Right.
then they say, I never received your note, letter.
That's why it's important to send by certified mail. If you send by certified mail, it's okay, right? Usually now you can do priority mail though. Usually there's tracking though. The law does not require that they received it. The law only requires that you sent it. That's right. Okay.
How about email? Is email okay for a comment?
Email should be good according to this provision. It says written notice though. An email qualifies as a written notice though. But frankly though, I don't want to do it by email. What if it goes into spam? Of course, you only need to prove that you sent it. That's right. That's what saves you, right? Okay. And always remember the option is personal to the original lease. Remember we went over this before. Let's say, for example, Anne has a loan. She sold it to someone else, and that someone else thought they have option. No, it's personal. Personal to the lessee. If it's transferred to someone else and the landlord never agreed, then the new tenant has no options.
So you told us last time, better to negotiate when you sign the...
That's right. Yeah, better negotiate when you sign, when you sell your business. Okay. Now, usually on the option, it also has this cost of living adjustment. If there's any cost of living adjustment, okay, to the rent, okay. It says here, fill in the cost of living adjustment rate, date. Sometimes you want to specify when the rent increase will be effective, so you want to put the dates here. Cost of living is like inflation. Okay, those are what we call cost of living adjustment. Okay, you want to put these dates in here. Okay. We also call that. Let's see here, CPI. CPI, you got the urban wage earners and clerical workers, CPIW, and then CPIU, all urban consumers. Okay, that's something that you have to look up online and then decide which one is better for your landlord. Okay. Usually we just simply say CPI, but apparently there's a difference between CPI-U and CPI-W. Okay. And then on your option, you usually want to indicate the base month. Now, if you look at this here, B here, it says the monthly rent payable in accordance with paragraph A1A of this addendum shall be calculated as follows. Base rent set forth in paragraph 1.5 of the attached lease. Now, remember, in your standard lease, you have the base rent. And then it says here, the base rent shall be multiplied by a factor, the numerator of which shall be the CPI of the calendar month 2 months prior to the, CPI of the calendar month 2 months prior to the month specified in paragraph A1A above, during which the adjustment is to take effect, and the denominator of which shall be the CPI of the calendar month, which is 2 months prior to. We will talk more about this option later on. Today we just get a general orientation about what are the addendum, okay? We'll go more in depth into this in the future. We don't have time to go in depth today. And then you also have, sometimes you can have a standard lease that has option to purchase now. In fact, I've seen some standard leases that come with option to purchase. What that means is that if you represent the tenant, you can negotiate with the landlord. Someday your tenant has the right, your tenant client has the right to purchase the property, like a warehouse. Sometimes you have a warehouse, the guy rents a warehouse, and he's already invested so much money in the improvement, he wants to have the option to purchase. So this is the form to use. It's called option to purchase. Okay? Option to purchase, remember, there are certain provisions that must be satisfied in order to make it a valid option to purchase. So one of which has to do with how you're going to determine the purchase price. Okay? Again, we don't have time to go over this today. We will pick a day just for that one particular form. Okay? Today we just generally understand what are the different types of addendum. Okay? All right, that's option to purchase. Let's talk about percentage rent. Remember, one of the standard leases have to do with shopping center. If it's a shopping center, sometimes a tenant has to pay a percentage of the gross revenue that the tenants receive in excess of a certain amount. So if there is percentage rent involved, this is the form you're going to use. Okay? This is kind of like the addendum that you're going to use for shopping center net lease. That's why it says here standard lease addendum. So if you ever have a percentage rent situation, this is the form you're going to use. Okay? And briefly taking a look at it, it has a definition for gross sales. Okay? And then it has a provision on books and records. I suppose they have the right to check your books to make sure you're telling the truth, right, about the sales. Okay? So this is the form you're going to use if there is percentage rent. Okay? All right. Let's go down. Rent adjustments. Yeah, this is an addendum actually. Let's look at it. Okay, rent adjustments. Sometimes you don't have enough room to write all the rent adjustments, so this might be a form that you want to use to address all of the rent adjustments. So it is an addendum, and it's an optional form. You're not required to use it because it is a little bit more complicated, okay, than the typical rent adjustment. So you may not even use it unless you become more experienced. Because most of the time, the rent adjustment will simply say, okay, year one, the rent amount becomes this amount. Year two, Year 3 is this amount. So you don't need to use this form because this is a more complicated form to use. Now, if you want to address the rent amounts in subsequent years, you can do it in the addendum. Okay? You can do it in the addendum form that I showed you earlier. Okay? All right. Right of first offer to purchase. This is also an addendum. Let me explain to you what this one means. It is an addendum. See, it's a standard lease addendum. All this means is, I am a tenant for this unit, and I want to have the right to buy the property from the landlord if the landlord is thinking about selling it. So before the landlord can put it on the market, the landlord has to come to me and ask me if I want to purchase it. Okay? This is what we call the right of first offer to purchase. In other words, it gives me the right to be the first offeror, okay, for this particular addendum. So if you represent the tenant, sometimes you may need to use this addendum, okay? All right, it's just the right to make the first offer, that's all. 99% you don't see residential. Okay, this is mainly for commercial. All right, and then right of now this right of thing, there are actually several forms. They are different from one form is different from another form. Okay, for example, this one here, right of first refusal to lease additional space. And it's also a standard lease addendum. What does that mean? Let's say, for example, you are thinking of maybe staying at the same place. As your business grows, you want the landlord to come to you if the landlord wants to lease out certain space. So you want to be the person to refuse to lease this additional space. So it's a form, okay? And it's a form if you are a tenant, you want to have the first right of refusal or right of first refusal to lease additional space, you can use this form, okay? Which means that if the landlord wants to lease space to someone else, he has to come to you. You want this space or not?
Do you want space out, but you cannot say, no, I don't want this out.
You can say, I don't want it. You can say, I don't want it. But you want the landlord to check with you first. Do you want this space or not? If not, I'm going to lease it to someone else.
Yes.
It's not the one next to you.
It could be next to you, or it could be some other location. You have to spell it out in your contract, okay? So as a tenant, you actually have some flexibility that allows you to expand your business. And you don't have to worry about, well, what if I expand my business, I run out of my warehouse space? You put something in here, the landlord is obligated to come to you. But if, let's say, for example, you lease a warehouse, do you want to have the option you want to be able to talk to the landlord, hey, I need to expand my warehouse. Do you have any space? If it's simply that inquiry, the guy can say, no, I don't have any extra space for you. However, if you have a right of first refusal for additional space, he can still say, I'm sorry, I'm not renting anything at the moment. But if you have the right of first refusal for additional space, if he should decide to rent out the vacant unit, he has come to you. Do you want this one or not? Okay, so that's the importance of the right of first refusal for additional lease space. Okay. No, he has to contact you. Do you want this space? I'm about to put it on the market. If you don't want it, then I'll lease it to someone else. Okay? Yeah. It's usually in writing anyway. Okay. Now, right of first refusal to purchase. This is something else now. This one means this is different from option to purchase, though. No, this right of first offer to purchase is different from right of first refusal to purchase. What is the difference? Right of first offer to purchase means he's thinking of selling the warehouse. And he has to call you or notify you that he wants to sell the warehouse and ask you if you want to put in an offer. That is the first offer to purchase, right of first offer to purchase. Right of first refusal to purchase is different. This one means he doesn't need to come to you if he wants to put it on the market. However, if he gets an offer that he's thinking about accepting, he has to present that offer to you. Do you want to match this price? That's the difference. In the first one, the right of first offer to purchase, he has to ask you to submit the first offer. If you don't want to, then he can solicit offers for someone else. Whereas in the first right of refusal or right of first refusal to purchase, he doesn't need your permission to put it on the market. However, before he accepts an offer, he has to present the same offer to you and ask you if you want to match that price. That's the difference, okay? Now, which one is better for the landlord?
Because at least you have one offer.
Well, actually, think about it. If I want to put the property on the market, right?
Why don't you pay the agent?
Actually, you know, if I want to put the property on the market, I'll probably have to hire a real estate agent, right?
Yeah.
Then I have to pay the agent's commission, right?
Mm.
But what if I have a right of first offer to purchase? Do I need to hire a real estate agent or no? Well, if you hire a real estate agent, when you have the right of first offer to purchase, you will only be getting the agent's opinion on whether or not the offer that is made by the tenant would be a good price, right? But if you think you are knowledgeable enough about the market, with the right of first offer to purchase, it seems like a better one because you can save on the agent's commission. Whereas on the right of first refusal to purchase, unless you're really good in marketing the property, you're probably going to need to hire a real estate agent because you know, he's going to advertise and then he's going to solicit offers. As soon as he gets the first offer, he will present it to your tenant to consider whether the tenant wants to match that price or not. And if the tenant refuses to match that, not just the price though, everything has to match. All the rest of the offer have to match, okay? So if the tenant say no, then this offer can be accepted by the landlord. But if the tenant say I want to match it, then this offer will be rejected by the landlord, and then the tenant and the landlord will enter into a contract, okay?
But for the first right of offer, you can do all you can to negotiate the offer with the seller, but they might not be come up with the agreement.
That's true, but
They find other buyers.
But you know what Chen Yi is saying, that landlord is not bound by the offer. The landlord doesn't like the price, but he gets to submit the first offer though. Now, however, on the right of first offer to purchase, there is a legal requirement that the landlord negotiate in good faith. It's implied that there's a, what does it mean to negotiate in good faith? It means that tenant submits an offer, right? He's just saying, I won't consider without a counter offer. Usually there must be some form of negotiation. You have to negotiate in good faith when you have a first offer to purchase, right? Right, or first offer to purchase, okay? All right, okay. All right, I lost the form, sorry about that. Okay. Let's go back and look at the addendum, okay? Now here, let's look at this one here. So now you see the difference between the right of first refusal, right? And also right of first offer. They are actually quite different. Actually, we went over these forms. The rest must be the addendum then. The work letter is actually an addendum, okay? Work letter to standard office lease. Let's look at that. Okay, that's another addendum that you might use. Now, if you don't know what a work letter is, it's basically an agreement between the landlord and the tenant regarding tenant improvement. You know what a tenant improvement is? Let's say, for example, you just found this space that you really like. It used to be a Chinese takeout. Now you want to run a yoga land on it. You know there's going to be some work that has to be done, right? So as a landlord, you want to secure this tenant. So in order to secure this tenant, you may be willing to spend some money to remodel the space. And the remodeling work is actually specified in the work letter. Okay? Now, if you read this stuff, you will say here clearly. Now, when you want to remodel, it's good to say here in your work letter, though, spell out what needs to be done. So it's got the date, and then it's by and between the landlord and the tenant. Okay? And then it will say, okay, what you need to do on partitions, how many partitions, and where you're going to put the partitions, wall surfaces, draperies, carpeting, doors. All this will be spelled out in the work letter. Electrical and telephone outlets, ceiling, lighting, okay, heating and air conditioning ducts, soundproofing, plumbing, entrance doors. And then usually the work letter has to specify, it says here, lessor shall construct and complete the improvements to the premises in accordance with the plans and specifications prepared by who? Here you put the name of the architect. And then it says consisting of how many sheets. So this is actually very, very professional. So if you represent the landlord and you have to do tenant improvement, you have to help the landlord prepare the work letter. Okay? And then it will say, you know, who's going to prepare the plans and specification, construction. And then usually, I believe somewhere in the standard lease, it will indicate the date of completion. Okay, and then these are just some standard provision by the heir. Work done by lessee. Any work done by lessee shall be only with landlord's of lessor's prior written consent. Acceptance of premises. It says here, lessee shall notify lessor in writing of any items that lessee deems incomplete or incorrect. So assuming that you have a good work letter, and once the work is completed, the tenant has to indicate within 10 days after the landlord delivers possession if they have any objections or anything that is incomplete or incorrect, and have to do so within 10 days. If the tenant fails to do that, then the tenant missed the opportunity to challenge the work. Okay? And then the term here, it says, upon completion of the improvement as defined in paragraph 16.3 above, lessor and lessee shall execute an amendment to the lease setting forth the date that lessor delivered possession of premises to lessee as the commencement date of this lease. So sometimes when there's tenant improvement work, you need to address when does the lease starts, because usually if you're a tenant, you want to wait until all the work has been completed before you move in. And usually most people want the lease to start when they move in. Okay, so this is a standard work letter that you will include in case of any tenant improvement work that needs to be done. Okay, I think that's pretty much all the addendum that we're going to be talking about today.